Consent calendar. All items are considered routine or implemented earlier council action and may be enacted by one motion. There will be no separate discussion unless requested by a council member, citizen, or staff. Questions or action on the consent agenda?
Move to approve consent calendar.
Through the chair, actually, I'd like to pull one item from
All right.
the consent calendar.
What item?
Item C.
C, okay.
I'll therefore move to approve items A and B of the consent calendar.
Second.
A motion is second on the question. All in favor?
Aye.
Item C is waived the first reading and introduce the ordinance imposing a 2.341 rate increase requested by Recology San Bruno for 2012-2013 to be effective July 26, 2012, as presented in the notice of proposed increase mailed to all property owners. Michael?
Thank you, Jim. This ordinance appeared before the council earlier, and we voted on it, and I believe we voted unanimously to pass it along with two other ordinances that I was told at the time did pass. Now they're being reintroduced. But rather than just have this go into the consent calendar, I wanted to make sure that we understand and inform the public in terms of what was changed in this version of the ordinance versus the original. And so if we could get some clarification, please.
The change in the garbage ordinance is the removal, an incorrect removal reference to the health and safety code that required a 2/3 vote of the council to approve the ordinance.
Okay. All right. Thank you. And if I could ask our acting city attorney if we could get some clarification on the reason why that language was changed.
As I understand, is this on? As I understand the issue, there was a recital in the initial ordinance that referred to a health and safety code section that referred to a voting requirement that's not accurate. So the reason we're having you reintroduce the ordinance is to make sure that the ordinance has the correct language in it and does not refer to an incorrect reference to a health and safety code section. The material terms of the ordinance are the same.
Okay. And I hate to put you on the spot because I know that you're walking into this and probably don't have a lot of the history, but in your experience as city attorney in other cities, has it been your experience that the reference to the health and safety code is fairly common in these ordinances as they pertain to city fees?
I would say it's just the standard is wrong for general law city. The 2/3 is not required. I can't speak to why it was in the original resolution or recitals of the ordinance, but
I can answer that. Let me just elaborate a little bit further. The specific health and safety code reference is for a 2/3 voting requirement in the event that the collection of the fee or charge that is the subject of the ordinance, whether that collection is via the property tax rolls. That is not the case here, has never been the case here, and frankly, staff is a little bit unclear. We do not know how or why that language appeared in the ordinance. It appears to us that it has just been carried incorrectly for a number of years in the same ordinance that we routinely present each year for consideration of the rates. The city attorney, who is on vacation tonight, originally opined that the error could be viewed as a minor clerical correction that would not have required reintroducing the ordinance for first reading or subsequent second reading. In an abundance of caution and in order to provide clear and complete opportunity for the public to understand what the action is, we've reintroduced it via the consent calendar.
Okay. Now, I'm certainly not an attorney, and I did read the text of the state constitution that was changed by Proposition 218, where it refers to this, and also the text of the health and safety code that addresses the same topic. And in my interpretation of it, I didn't see that that particular piece of the health and safety code addressed only a situation where it would be put on the county tax roll. There was some mention to it, but I don't see it specifically addressed in the section that addresses the fees. And it almost seems like the two pieces of legislation, they overlap, with one being more stringent than the other.
Well, I understand that it's a very complicated area of statutory and constitutional authority. I've done, in the other city I represent, we just did our garbage rates a few weeks ago, and we did it by ordinance, and we did not require a 2/3 vote. I think that's the rule. We do not, just like San Bruno here, we do not put it on the property tax roll. It's a rate-setting procedure whereby it gives the city council sets the rates for the service that's provided through your franchise with Recology, and then that is the authority for Recology to put that on a regular bill that goes to the residents.
Okay.
So I can't speak to why it's 2/3 to put it on the property tax roll. It's probably a technical or policy reason that's because it's something that is more formal, if you will, because it's requires a action in involving the county tax collector. That may be the reason I'm speculating a little, but the main point here is that, and I've talked with Mr. Zaffarano about this particular issue, that the solution to the issue of the reference was to reintroduce the ordinance. We're confident that the issue that the process is appropriate. It does not require a 2/3 vote.
Okay. And my final question, if for some reason somebody challenged the city on this particular thing because the language was changed to a less stringent version of the language, worst case scenario, we would just have to repeal the fee increase, or could there be other consequences to the city?
Well, that would involve someone taking the city up on a writ to require the proper procedure. We believe that we are employing the proper. Thank you. That would entail. I'll repeat myself for the benefit of the audience and the recording. That would entail a writ proceeding in Superior Court where someone would say that, in essence, that the council did not follow the right procedure. That would be their allegation, and the remedy in court would be do it the right way if that what happened to be the wrong way. But the process you're employing is the correct way.
Okay, thank you. All right. With that, I will introduce. Okay.
Just
So
introduce 7C.
Okay. So, all right. So I'll move to approve item C on the consent calendar.
Second.
Motion second to approve the consent calendar, item C. On the question, all those in favor?
Aye.